so that you would not have, say, 4 people from one party and 2 people from one body, the other party, in effect ganging up on the 2 people that would be most negatively impacted.
Mr. Chairman, so 2 senators can, from the same party can thwart the whole process and send it to the Supreme Court, correct?
They would be able to block it from being an action that would be taken by the full commission, even in this case, even if you had the 6 of the 8 members that were there voting for it. And because of that, then it would not go to the House of Delegates and the State Senate for an up or down votes.
So the answer is yes.
So the answer is yes, that we could put it back there.
And
then we have incorporated, as I'm sure you're aware, within the Senate Bill 203, procedures for the Supreme Court that provide for 2 special masters, that type of thing.
We'll get to that, I assure you.
We've tried to balance things out as best we could throughout the whole process and make sure that we're taking care of all the potential problems we might have.
Senator Barker, this is going to be very helpful. You are an encyclopedia of knowledge, and you answer your questions very completely, and I thank you for that. But so much so that probably half of what you say will have already addressed the issue. And what I'm trying to do is get to the people behind us.
I agree.
Because I think they're the more important people to be dealing with this issue.
So,
right. Delegate Levine.
2 senators can thwart the process, correct? And send it to the Supreme Court.
If the 2 senators are from the same party.
Yes.
Yes.
And 2 delegates from the same party can also thwart the process and send it to the Supreme Court.
That's correct. From the same party. Yeah.
And the language of the part going to the Supreme Court is the district shall be established by the Supreme Court of Virginia, correct?
Correct.
Okay.
Which is the case here and basically in states all across the country.
When a Virginia law is inconsistent with the Virginia Constitution, which prevails?
When a Virginia law is inconsistent with the Constitution prevails.
Okay. So looking only at the constitutional amendment, SJ18, am I correct to say that there's no prohibition against gerrymandering, apart from racial gerrymandering, which is illegal under federal law, but apart from racial gerrymandering, the constitutional amendment does not prohibit gerrymandering, correct?
The constitutional amendment does not dictate to the commission how it's going to draw the districts other than the types of things that you referenced as it relates to the racial issues and everything.
Okay, so gerrymandering is allowed by the Supreme Court if they establish the districts according to the constitutional amendment.
Now, what we did pass criteria this year, so there are a number of other additional things that have to be taken into consideration there. They're not part of the constitutional amendment, but they are part of the enactment legislation and the legislation that we've already adopted. So,
okay, I'm going to get there.
Delegate Levine.
Thank you, Mr. Chairman.
No, Delegate Levine, please allow the patron to finish his sentence.
I will, Mr. Chairman. Communities of interest
yes.
Are not in the constitutional amendment. Is that correct?
That is correct. They are given a prominent position within the enacting legislation, but they're not listed separately in this provision.
And Senator Barker, this amendment was not your first choice when you first proposed it last year. Is that fair to say?
Well, I've had a number of different options that I've tried over many years. So it's not. So I've been trying for years to find something that would address a lot of the issues that people had raised, legitimate issues, in terms of what could go wrong with things. So what we had to do here was to come up with something. We came up with something that addressed as many of those issues we could identify and correct here, left it to the enacting legislation for the rest of it, and I think have addressed those issues overall in a way that will help the system be able to work properly here.
And there are no criteria in the bill either for how to draw districts other than we shouldn't violate federal law. Is that fair to say?
Yeah, I mean, there have been criteria in the Constitution all along related to contiguous and compact, but those have not been defined there. So we've had limited criteria within the code in Virginia. So part of what we did was we worked this year to be able to have criteria that would be used next year, regardless of whether it's a constitutional amendment that's setting up a commission or whether there's some other process that was developed if the constitutional amendment did not pass, to be able to apply those criteria regardless of who's drawing the maps.
Thank you, Mr. Chairman. At the appropriate time, I would like to speak to the bill.
All right, Delegate Cole.
Thank you, Mr. Chairman. Just have one question for the patron. If there's a time crunch I mean, the General Assembly certainly has the authority to reschedule or delay the primary election. I know in 2001, when I ran in a primary, the primary was actually in August rather than June. So if there's a time crunch, the General Assembly could certainly delay the primary election to give the General Assembly or the Commission more time. Is that not correct?
Well, it's actually not more time to the commission. I mean, more time, obviously, than if you were trying to hold a June primary. But Virginia has consistently, on years ending in 1, had primaries that have been actually, when I first ran, I was not successful then, but it only took me 16 years to get elected. But when I first ran in 1991, the primary that was held then was, I think, on September 15th. So in the past, they've had lengthier times. Right now, in 2011, what happened was the primary was held on August 23rd, which is a famous date because that was when the earthquake hit in Louisa County, right in the middle of an election. And I've talked with the people with the Board of Elections, and they indicate that the latest they could hold a primary and be able to meet the timelines established under federal law right now would be roughly somewhere between the 20th and 25th of August. So, and have whatever days is the Tuesday that week. So.
Delegate Krezek.
Thank you, Mr. Chairman. I just have 3 questions. Why didn't you address gerrymandering in your constitutional amendment?
What we did was we tried to provide as much flexibility as we felt was reasonable within certain principles there. One of the challenges you would have, depending upon some of the types of things that have been proposed in the past in Virginia in terms of trying to address this issue, have been adopted in other states, and it have basically ended up on a lot of the action being in court rather than in drawing the lines. So you end up with that risk there. What I think paramount was here was to make both political parties feel comfortable with this process so that there were protections built in that you could be able to advocate for the type of districts that would be fair. And I think that by and large, what you end up with when you have a balance between the two parties and in these types of processes is that you end up with fair maps that are, as it relates to the overall distribution of the political parties, the overall strength of the political parties. What you do end up with, and sometimes, is that the districts are not always as competitive as I would like them to be. And actually, one of the things I tried with a couple of the amendments done over the years was to look at competitiveness of districts as well as some of the other criteria there.
Delegate Krezek.
So why not a nonpartisan commission? Why did you include any of us?
Well, 2 reasons. One is on the commission itself, and then the other is the action of the General Assembly thereafter. I think that in my discussions with a lot of people in the Assembly, people, both Republicans and Democrats, were much more comfortable if they were at the table and could protect their interests than leaving it to something that was developed without the involvement of legislators in the process. And so, I think if I had not done that last year, provide the opportunity for enough legislators to be there, there's a good chance it would not have passed last year when it did pass overwhelmingly in the Senate and by a substantial margin within the House. The other
Delegate Krezek, last question.
Okay.
So my last...
Mr. Patron, you're going to get the final word, but I really want to get to the people behind you.
I understand.
Thank you, Mr. Chairman. My final question is really about both of the first 2 questions. So this constitutional amendment could not prevent, it is very possible that you could still have a gerrymandered map because you'd have the politicians from both parties maybe working together, and that is certainly within the realm of possibility, just looking at the constitutional amendment, that you could have some gerrymandering going on. Am I correct?
Well, you could certainly have odd-shaped districts if that's what you're talking about in terms of gerrymandering. That's not inconceivable under this because we did not attempt to try to quantify, what that would be. There are provisions. There are court cases that have helped address issues such as compactness standards there, and that's something that I think we would use. That was something that we used in the Senate in 2011 in drawing our district. We made sure that in the end they met all the compactness standards that the courts had established there.
Delegate Van Valkenburg.
Thank you, Mr. Chairman. Mr. Chairman, Senator Barker, I guess kind of pinging off of what Delegate Krizak said, I guess it's a two-part question. First part is just a simple answer, right? Is a district like mine, which everybody knows what it looks like because it's all over maps, it's all over all the paraphernalia and propaganda everywhere, right? Which is a backwards U, which was used to scoop up enough Republicans to keep that seat safe, right? For at the time it was Delegate Massey, before whoever, right? Would a district like that be more or less likely under this commission?
I think it would be far less likely, because what you have is 8 citizens who are there going to say, we don't like to look at this. And you're going to have legislators who would be potentially disadvantaged, see their party as being disadvantaged by such circuitous district there to try to help one political party. So I think that, that we have a couple of protections that are built in.
Thank you, Mr. Chairman.
All right, the only other person in the queue is Delegate Levine. And I'm assuming after his question, and I put that singly, that we would then be looking to open it up.
You're testing him, so.
Thank you, Mr. Chairman. I will ask one question. Assuming you're aware of the United States Supreme Court decision last year that held that it was not going to look at gerrymandering unless it was racial gerrymandering, isn't it true, Senator Barker, that if the Virginia Supreme Court were to do any kind of gerrymandering it wanted under the constitutional amendment alone, that didn't include racial gerrymandering, there would be no place to appeal it, no relief, we'd have to accept those districts?
Mr. Chairman, members, Delegate Levine, members of the committee, the situation is that in that predicament there, what you would have is a situation, if, I presume that where you're saying that there is no basis for lodging an appeal on racial gerrymandering, that then there would be, within the federal courts, no other provision that would be available there. And since it's the Supreme Court that draws the maps, which is not unique to Virginia. I mean, basically every state operates that same way, that's the backup in terms of what happens if the legislature or whatever body that's involved is unable to come up with a map there. That, they're the ones that would be making that decision. Now, we have attempted to address that in the enactment legislation this year, but it's not incorporated in the constitutional amendment. I mean, we're trying to be sort of more truncated within the constitutional amendment itself and count on the enacting legislation to address some of these issues.
Thank you, Mr. Chairman.
Delegate Price, final question.